Assalamualaikum warahmatullahi wabarakatuh. My name is Ustazah binti Tajul Urus, lecturer from Kuliah Syariah and Laws, MAXIMS. So insyaAllah, I will present a topic on a brief discussion of the use of preferred Islamic legal maxims in Malaysia with regard to the pronouncement of talak outside of court. So these articles examine how Islamic legal principles are used in Malaysia to declare talak outside of court. This article goals is to outline the Islamic legal principles that judges find most persuasive when deciding divorce cases. In order to analyse the role of preferred Islamic legal maxims as an argument in Islamic law and to investigate the position of the writing of judgment in Islam, the notion of divorce was investigated to see preferred Islamic legal maxims as an essential part in the submission of each case. The two main procedures used in this data is data collecting and data analysis were used as an qualitative approach. In the Malaysian states of Kedah and Kelantan, information was obtained over the course of 4 months in 2017 through document analysis and interviews. In order to learn more about the use of preferred Islamic legal maxims in judgment and the practice of judgment writing in divorce cases in Malaysia, 2 academicians and 4 legal practitioners were interviewed for this study. The study also looked at the position and significance of judgment writing in Islamic law. The content analysis method was used to analyze the data. The respondents' documents were analyzed using this technique in order to gather specific data on how to apply the desired Islamic legal maxims in divorce cases. The study's findings imply that when dealing with Sharia cases, decisions and supporting arguments often rely heavily on legal maxims. Al-Quran and Al-Sunnah must be parallel by the preferred Islamic legal maxims which contain the Maqasid al-Sharia values. It is hoped that society may entrust Maqasid Sharia with handling divorce cases given the frequency of family issues today. Collaboration between Sharia judges and solicitors aids in creating novel elements incorporating both religious and legal considerations. Islamic legal principles will increasingly be used, and this will have a significant impact on institutional and religious courts, particularly to the Sharia courts at the national level. The purpose of this application is to clear up any misunderstandings between the parties concerned and the Muslim community as a whole. Okay, now we go to the concept of divorce according to Islamic law. Two perspectives, namely Islamic law and legislation in Malaysia, can divided Islamic law divorce in Malaysia. According to the Islamic law, divorce is a lawful action in terms of religion, but is despised by Allah Subhanahu Wa Taala. This means that divorce is allowed by religion, but it is the last resort chosen when all the means to reconcile the married couple who have failed. Thus, divorce has to be done for the betterment of those involved. In this context, divorce is commonly known as talak from the legal point of Sharia. And then, according to the law, Islamic law in Malaysia, so this is the role of Section 47 of Islamic Family Law Enactment, which stated that in order for a married couple to apply for a divorce, they need to fill in prescribed form accompanied by an ikrar containing matters related to the divorce marriage information. The courts which has the jurisdiction, the previous information related to the proceedings ever made in divorce, the information pertaining to work undertaken to achieve peace, entitlements and benefits promised to the wife and children after the divorce, and any details on the order requested. Okay, talak outside the court. Talak that is pronounced outside the court and without court consent is an offence pursuant to Section 125. If convicted, the duo will be liable of a fine of not more than 1,000 ringgit or to imprisonment not exceeding 6 months or to both. Although the value of penalty is low, the impact on marital status is particularly intense, especially to the wife. Hence, this paper explored and discussed thoroughly on the implication that will occur if this matter is not taken seriously, which will then prolong the suffering experienced by the victims, namely the wife and the children. Thus, in order to avoid the occurrence of marital status in marriage, then each married couple need to understand and familiarize with the provision of the law so that any action in marriage is in accordance with the correct legal structure. So this issue was raised when the talak application procedure being pronounced in the court continues to be questioned by skeptical religionists and society who say it does not follow the law of Allah as found in the Quran and Sunnah. So the practice of divorcing couples by pronouncing divorce is not in court. It is a contradiction with the law enforced in this country. Thus, this paper will highlight what exactly should be elaborated and understood by the public so that the implication of divorce can be controlled and disconnected wisely so the divorcee gets their rights fairly and equally. So, interviewed respondent Indonesia. So, 2 respondents has been interviewed. So, both of them are the judges from the Sharia court. So, the first respondent explained the court usually use 5 maxims, okay, when they deciding talak outside the court. So, the maxims are al-aslu adam, yarida dalil ala tayyirihi, qalabatazun, at-talafus, and at-talak bil kitabah. Whereas the second respondent gave 2 maxims that are similar and appropriate to be used in the talak outside the court. The maxims are tasarruful iman, manutun bil maslahah, and al-aslul adam. So the findings show that the judge applied the implemented preferred Islamic legal maxim in their judgment. In the preferred Islamic legal maxims is contained the maqasid Sharia values themselves in parallel with the Al-Quran and As-Sunnah. So therefore, this article hopes that a humane society is able to entrust maqasid Sharia with the family issues occurrence in modern day. Sharia judges and lawyers should be of assistance in helping to develop innovative elements comprises religious and legal aspects. Such application and trends will have a huge impact on the profession of religious and institutional courts, in particular the Sharia courts at the national level in the global era. So this application is aimed to prevent confusion among the parties involved, specifically Muslim community. Alright, for the suggestion, firstly, this article affirms that maqasid Sharia has been used to the Islamic family law enactment as a benchmark in order to make sure that the law is parallel to the context of hukum Sharia. There is no doubt for the religious to argue on the difference between the law and the hukum Sharia. Secondly, Sharia judges must apply the Islamic legal maxims, at least 2 appropriate maxims, when deciding the case, especially in the case of talak outside the court. The guidelines has to be drafted and spread to all states and must be followed by all judges in their judgment. So for the conclusion, therefore, the importance of this study is to provide a deeper explanation of the role and application of preferred Islamic legal maxims as a legal argument. Also to enhance the understanding of the community towards the appreciation of the Islamic legal maxims and is able to understand the law of the problem that have been missing in the Quran and Hadith. So in conclusion, strong collaboration between religious groups and legal experts are important and should be given priority. So Alhamdulillah. So wassalamualaikum warahmatullahi wabarakatuh.